representing Mississippi, elaborated the state's case.
When does a woman's interest enter? As far as we're concerned, it's there the entire time. Our point is that all of the interests are there the entire time, and Roe and Casey improperly prevent states from taking account and weighing those interests however they think best.
Julie Rickelman, representing the abortion clinic, stated,
"The court has interpreted liberty to include the right to make family decisions and the right to physical autonomy, including the right to end a pre-viability pregnancy."
The justices focused on whether they should overrule Roe v. Wade. Describing Roe v. Wade as a watershed case, Justice Breyer stated,
"To overrule under fire in the absence of the most compelling reason to re-examine a watershed decision would subvert the court's legitimacy beyond any serious question."
Justice Sotomayor agreed, warning,
"If people actually believe that it's all political, how will we survive? How will the court survive?"
But Justice Kavanaugh disagreed, stating,
"Why then doesn't the history of this court's practice with respect to those cases tell us that the right answer is actually a return to the position of neutrality?"
The justices also probed at the viability standard in Roe and Casey, with Justice Alito stating,
"The line really doesn't make any sense, that it is, as Justice Blackmun himself described it, arbitrary."
However, Sotomayor seemed to disagree.
What hasn't been at issue in the last 30 years is the line that Casey drew of viability.
Talking Points analyst Spencer Kweskin joins us now. So Spencer, what are the possible outcomes for this case?
Yeah, so with the composition of this court, there are really three possible outcomes for the case. The first is that Roe v. Wade and the viability standard are upheld. This would be very similar to the Casey decision. In that case, there were 8 justices who were conservative justices and 7 justices who directly opposed Roe v. Wade. However, despite that, the court upheld Roe v. Wade. So this coalition would look very similar. It would be the liberal justices, it would be Roberts and maybe Kavanaugh, who has talked at length about precedent, or maybe Amy Coney Barrett, who is sort of a wild card in this case. The second option is what Roberts described during the hearing, and that is moving the viability line somewhere else. Now, Amy Coney Barrett referenced moving the line up to maybe the second trimester, but it could also be moved down to maybe the first trimester or to Mississippi's 15 weeks. If it's moved down, then we're going to look at challenges at 10 weeks, at 8 weeks, at 6 weeks even, and there'll be a lot of challenges. The third possibility is that the court overturns Roe v. Wade effectively. And the way they would do this is similar to how they did it in Brown v. Board of Education, where in this case, they would say viability is a nice standard and all, and it's a good idea in theory, but in practice, the federal government either cannot or should not be setting the line, and therefore, the court cannot make a decision on this, the federal government can't do this, and so the issue is kicked back to the states.
All right, Spencer Kweskin, thank you so much.